Yes.
I'd like to move a IA petition by today itself.
Tomorrow.
Tomorrow.
Yes.
Motion. Item number 1.
Yes, Mr. City.
Dear Mr. Lord, petitioner is before his honorable court in view of his released order with a retrospective date, which is contrary to the records maintained by the department as well as by the PNR department. Initially, he was appointed on 2nd of August 1988. Thereafter, extension order was issued in the month of September in 1989. And then another last extension order is on 17th of November 1989. There, although it is shown as an extension order, his previous extension order lapsed on 31st October 1989. So there is, after a gap of 16 days, he was given extension order. And there has been series of anomalies in view of this break in service and all this. Department has taken 17 November 1989 as the determining date for counting his service. And date of training has been determined from that particular date. That is the last order, which is on 17th of November 1989. And the matter has also been referred to the PNR, and in view of a lot of anomalies, to overcome all these hurdles, they have taken this 17th of November 1989 as the date of training of the petitioner. And accordingly, the department has also shown in the seniority list, even in the month of July, they have shown this as my date of retirement will be 17th of November, 30th November 2024. But from a retrospective date, I have been in list. Can we see the order, Lordship, my initial appointment order at page 24? My appointment is as LDA in the office of the Advocate General Nagaland, station at Gauhati. Although the order is issued on 2nd August 1988, the effective date was shown as 20th June 88. That is how they have made it to retire on 30th from the month of June, Lordship. And this appointment order has been extended by an order of 26 September 1989.
So page 24 says that your date of joining will be effective from 2689.
Yes.
88.
2688. And then can we come to the next?
So the department has taken this date. Department has taken this date to release you.
For release. But other documents are referred. 26, this is the type copy of the extension order. And Lordship will find in the last line of the order, till 31st October 1989. Page 26. Type copy is more clear. So this extension is up to 31st October 1989. Thereafter, next page, page 27, Annexure C. Although type copy is enclosed, but this order is legible. So let me rely on this. 17 November 1989. This is issued in continuation with the earlier order of 26 September 89. Until this is shown as an extension order. But then the earlier extension order has been lapsed on 31st October 1989. And after a break of 16 days, this extension order has been issued on 17th of November 1989. Nowhere it has mentioned about the connectivity also, although it is shown as an extension order. So there is a lot of anomalies and discrepancies. In view of this, The department has determined a date. Kindly come to page 64. Page 64 is the office memorandum issued by the department, the Law and Justice Department. It is issued on 6 July 2023. The tentative seniority list of LDS and UDS under prosecution establishment was on 31/4/2023. Since he has been placed under the prosecution wing, he has submitted, the petitioner has submitted a representation. And next page, Lordship may kindly see. No, before that, the last line of the order. If no representation is received within the stipulated time, this tentative seniority list shall be treated as final. So that is the condition. And next page, page 65. In the speak of the petitioner, extreme right, from the right second box, date of retirement is shown as 30/11/2024. That is counting from the date of entry into service in the middle column, 17/11/1989. This is by no other than the Law Department. Date of training is 17/11/1989 and date of retirement is 30/11/2024. After this, Lordship may kindly come to page 69, that is the last page. This is the extract of the website from the PNR, maintained by the PNR department. In this page, the serial number 3, the bottom, name is shown in the column number 2, and the third, the post is shown, and the office is Secretary, Justice and Law Department.
Date of joining.
And then date of joining is shown as 17/11/1989. This is on the basis of the PIMS by the PNR department, which is also the nodal department. They are also very clear. But then maybe in view of the lot of litigations which the petitioners have been trying to assert his right in accordance with law, the department turned to be a little hostile also. And just I'll refer to one document, Lordship. The order passed by the Secretary Law on 19th of July 2023, page 54, Annexure O. I will refer only to the last paragraph at page 55. This is an order by the Secretary Law, Department of Law and Justice, where my RTI application has been rejected. See how vindictive it is. Kindly see the last paragraph, Lordship, page 55. Has Lordship correct? May I read, Lordship? First, appellate authority, in order to keep ample opportunity to address the grievances of the appellant, fixed on 33/2023, 24/2023, 17/5/2023, and 14/7/2023. However, in spite of presenting his grievances, he has undermined and insulted the authority of the first appellate authority with the word. The direction of physical appearance before appellate authority is uncalled for and dehones the rules of the RTI Act. That instead of cooperating to the authority, rather challenge the authority, which attracts unbecoming of a government servant, attracting disciplinary proceedings under the Nagaland Government Servants Conduct Rules 1968. The intention and motive of the appellant appears to be nothing but to harass and torture the authority by misusing the rights as conferred to all the citizens of the country under the RTI Act. Therefore, with the observation above, the appeal dated 15/2/2023 stands dismissed. By asserting my right, because under the RTI Act, the procedural appearance is not mandatory. Therefore, the petitioner has submitted the written statement in detail. Each point has been applied. So, if the petitioner failed to attend, they could have considered whatever has been submitted in black and white and pass appropriate orders. instead of taking it personal in a vindictive manner, Lordship. Maybe these are the reasons why they have taken a decision to release me from service with a retrospective date, contrary to the records maintained by them.
Okay, we'll issue notice today.
Lordship.
Yes.
And I have also prayed for a stay.
Stay interim. Let us also hear the government at least.
Lordship.
Because as it is, you are now out of service. Had you been in service?
Of course, that is illegally and arbitrarily they have released me.
Of course.
So that may be examined by this honorable court.
Yes. Heard Mr. C.T. Jamir, the learned senior counsel for the petitioner, assisted by Mr. Im Kong. Im Kong, correct? Im Kong.
His whole name is MT Senate.
Oh, Im Kong. I'm always
He has
confused.
run the entire city.
Yes.
MT Senate.
Im Chen, learned counsel. The petitioner has been retired from service as HA in the office of the Advocate General, Nagaland, Gauhati High Court, Gauhati, under the Department of Law and Justice. Stop. The petitioner is aggrieved by the order dated 17/8/2023. 17/8/2023, releasing him from service, with effect from 36/2023 on attaining 35 years of service.
Allegedly,
That's all right, it's all right. Attaining 35 years of service. It is the case of the petitioner that his date of joining the service is 17/11/1989, and therefore his date of retirement should be 30/11/2024. Stop. The learned senior counsel has taken this code to the office memorandum dated 6/7/2023, issued by the Department of Justice and Law and Justice, Kohima, showing the tentative security list of LDAs and UDAs under prosecution establishment as on 31/4/2023, where the date of entry of the petitioner in service is shown as 17/11/1989, and his date of retirement as 30/11/2024. Stop. The learned senior counsel has also taken this code to the printout taken from the website of the PNR department, where it has been clearly indicated that the petitioner's date of joining service is 17/11/1989. Stop. This being so, it is submitted that the department could not have given an artificial date to retire the petitioner from service with effect from 30/36/2023. Stop. Issue notice to the respondents, returnable within 4 weeks. Since MS Mary, learned senior government advocate, accepts notice on behalf of the state respondents, no formal notice need be issued. The learned counsel for the Mr. I. Im Chen, the learned assisting counsel, shall however serve requisite copies of the writ petition to the learned government advocate within,
in the course of the day.
in the course of the day, listed after 4
We are
weeks.
furnishing the copies right now.
Okay. Stop, listed after 4 weeks.
And interim may be considered on the next day.
The prayer for interim shall be considered on the next returnable date. Yes.
Highly applied.
of admission. Item number 2.
Yes. What is this?
Order passed on 19/6/23 has been complied with, Lordship.
You have paid the cost?
Yes, Lordship.
Okay, very good. You have paid the cost? Okay. So you have received the cost?
Yes, my lord.
Yes, good. So what is your case now?
Your Lordship, on 16/3/2023, this honorable court has given one direction. Let both the party sit together and settle the matter amicably.
Which one? Which order?
On 16/3/2023.
16/3/2023. Okay. Rising out of all possible opportunities should be extended to the parties to resolve this. Yes.
Yes, Your Lordship, once they have informed me to come and meet in Assam, whereas Your Lordship, the respondent number 1,
Assam?
yes, Your Lordship, they have given one message that the petitioner wants to meet the respondent in the state of Assam.
Who is the petitioner?
Petitioner is from Arunachal.
My lord, that is the center point.
That is the center point. Then why have you registered the case at Kohima?
My lord, the thing is, this, the petition.
You cannot have the cake and eat it too.
Yes.
Yes.
Your Lordship, thereafter, on several occasions, we have requested the petitioner to let us comply the court order. Your Lordship, they have told that they do not have any contract with their client. And till today.
Contract with their client?
Yes, Your Lordship, we have informed the counsel of the petitioners, let us comply this court order and let us sit once and let us find out some amicable settlement. However, Your Lordship, the counsel have informed me that their clients are not responding their calls, and till today we cannot sit.
My lord,
What is your case? Basically, it's a arising out of an agreement.
yes,
You
my
go to
lord,
civil court. We'll dismiss.
this is purely civil matter.
Or you go to civil court.
Yes,
But Your Lordship.
My lord, my
Your Lordship.
Are you not willing to take any opportunity to amicably settle the
no,
matter?
I read one, but the thing is, my lord, the petitioner number 1 has brain surgery. So the doctor advised him not to travel far distances. So that's why we have requested him to come there and settle in Gauhati. So they are not willing to come. That is the reason, my lord.
So
They are not willing.
you take a middle place, not Gauhati, not Kohima. You take a middle place to settle.
But when we asked them to come to Arunachal, they are not willing to come also.
Your Lordship, we are agreed to sit anywhere, Your Lordship.
Yes.
If they are ready, also come, they are not, I'm ready, my lord.
We are agreed to sit anywhere, Your Lordship, but just since the respondent number 1 is a senior citizen, she is a lady, so a suitable place so that she can travel, and any unknown place she is not feel safe. So either Dimapur, because
My lord, they can come up to Arunachal while signing the tripartite agreement.
Why Arunachal?
Actually, when we entered the tripartite agreement, they came to Arunachal and we executed the tripartite agreement. Okay.
Then file the case in Arunachal.
My prayer is only that,
If you want to really amicably settle the matter, you take a middle path.
yes, we want.
You take a middle path.
Yes, we
Don't
want.
be rigid. Don't be rigid in your stand. Don't say that without Arunachal, no compromise. If you take that stand.
No, that's not the case, my lord.
uh,
Anywhere it's okay. But I have already intimated him and requested him to come up to.
Yes.
Lordship,
But
we
that
are
is not
agree,
my
your lordship.
You go to Gauhati,
Lordship, we are agree.
they,
Let us fix one date, Lordship, because from the last 4 months, I'm asking them, but they said that they do not have any contact with their client. Their client is not responding their call. So that was the reply we got.
so Mr. Kasar,
Yes, my lord.
you actually advise your client that it will be always good to go for settlement?
Yeah, definitely.
Because actually, like if you go on with the litigation, in the end, it may not benefit anyone.
Yes, definitely I'll do that, my lord. But my prayer before this honorable court is to cost CRTS 1 pending trial before the Chief Judicial Magistrate Timopur.
GR.
Yes.
Or CR.
CR.
Okay.
Your lordship, the
Yes.
fact of, your,
Just wait, just wait.
After that, we can settle anywhere.
I'm
not running away.
So what happens to,
So they have falsely implicated, they have falsely filed this case against me. Actually, it is,
is there a stay?
yeah,
Is there a stay of the proceedings?
yes, stay, the posting is state.
Okay.
My lord, the case is purely civil in nature. And to this effect, we have entered into a bipartite agreement. And to this effect, the respondent have invested 2.50 crore rupees. And then we were jointly executing the contract work. And thereby I have paid 3 crore 43 lakhs, or 3 crore 46 lakhs. Now, as per their request, 19/3/2019, I have issued a check, a bundle of check containing 49 leaves. And I told them that there is no money in this check. So whenever you want to withdraw, please let us keep in touch. So they were willingly accepted.
Why did you give check without money?
No, they are insisting. So I told them in a in heart that there is no money, but they were insisting. Whatever money is, they want to just give me your check in good faith. So I have given them. They know that there is no money because I have told them. And in the meantime, the account was closed. And I have already communicated them.
Your account was closed.
Yes, and my.
Okay, leave aside the record.
Yes.
Let me hear from you.
After that, they went on to the bank and deposited the check. Obviously, they know the account has been closed. And now, thereby, after 220 days, they have issued me a legal notice. And then I have replied them, no, I have already informed you that the account has been closed. Rather, you should please kindly return me the invalid check. Till date, they are not doing so. And then, after which, again purported legal notice they have issued me. But I have never received that legal notice. In fact, they never served me a legal notice second time. And after that, they have filed this CR case in Timapur. Then they did not give me even the complaint copy. So there is a complete non-compliance of CRPC 204. Actually, everything should be there. Through court, CDC, I have applied and I get the documents, all the documents. And now, they have filed a case against me, they found case under section 138. But that provision also they did not follow it. And now may I read my lord, the proviso here. My lord, may I read the proviso A. The check has been presented to the bank within a period of 6 months from the date on which it is drawn or within the period of its validity, wherever it is earlier, whichever it is earlier. B. The payee or the holder of the due holder in the due course of the check as the case may be, makes demand for the payment of the said amount of money by giving a notice in writing to the drawer of the check within 30 days. So, my lord, they have never written a letter to me and they have deposited the check after more than 2 years. Actually, the law is very clear. It should be deposited within 6 months. So they are not complying even the provisions of CRPC or NIA Act.
Do you admit to your liability?
No, I have no liability.
You have no liability.
Yeah, actually it is a joint contract work. I have no liability.
And what happened to the joint venture work?
Now, because of this case, I could not pursue the matter, and COVID also came there.
Where is the place of the
It is
contract?
now manager, my lord.
Okay.
So that is the case.
So the contract was that he will, the respondents will invest money and you will carry out the contract. And
Yes.
you will share the profit.
It is 50-50. And now I have already given him more than 3 crores. I have invested only 2.50 crores.
Okay, you make an endeavor,
Therefore, I have already, because we'll sit together, most of profit will work out.
Yes.
And if it is lost, we'll equally share. And if there is profit, as per the together agreement, we'll have to equally share the profit. But they are unnecessarily filing a case against me, CRPS, check bound case. So it is quite unnecessary and they are misusing.
Maybe
Triggers.
maybe the CR case has been filed for default because it is you who has issued the check.
There is nothing for your honor.
Default.
My lord.
Yes, when you know that you don't have any money in the bank, you are issuing check. In spite of his insistence, I think you should have avoided that.
My lord, I am in Arunachal and they were in Dimapur. So in order to have a good transaction, actually I have issued in good faith. I never thought that they will misuse this. But now they are trying to tarnish my image. They are trying to embezzle the money. They have used 4 checks. If there is money in my bank account, then they should have withdrawn already 10 crores. And I have paid him only more than 3 crores. So it comes up to 14 crores.
Knowing that you don't have money, you have issued the
And
check.
now, my lord, the contract work is only 17 crores. When they have taken all this 14 crores, how will I work?
They have taken 14 crores.
No, if suppose there is money in my bank account,
You have issued a check knowing that there is no money.
yes, then I.
So don't take that plea. Don't take that plea. Anyhow, we will give you one more opportunity.
My lord, therefore, my humble prayer and submission before this honorable court is kindly quash this order. Kindly quash.
No. We will give you one more chance because actually the stay is still in operation.
Yeah, stay is still in operation.
Yes.
Yes.
So no harm will come to you in spite of the pendency of the CR case
Yes.
since the stay is in operation. Stays in operation till the next returnable date or till further orders.
There's no time, my lord.
What is that? Let us see.
Please. Oh, my lord, since our triple agreement has arbitration clause, so
Oh.
may this honorable court.
Let us see your let us see your agreement. Let us see your agreement. Let us see your agreement.
My lord, my arbitration clause is page 26.
Page 26.
Yes. It is in page 28, my lord, the bara 5.
Yes.
Here the para 5 states as follows, that all disputes and questions arising amongst the parties in connection with the execution of this contract work or the terms and conditions stipulated in this agreement shall be referred to the arbitrator in accordance with provisions of the Arbitration and Conciliation Act 1996, then in force. That is our petition closed, my lord. So therefore.
Okay, so as a first step, we will allow you to avail an opportunity to amicably settle the matter. Okay?
Your lordship, I would just take 2 minutes, your lordship. Very peculiar things are there, your lordship. Petitioner number 1 is the one who got the work order. Petitioner number 2 and 3 is the special power of attorney holder. Now 2 and 3 contact me and he told me to finance in that contract. And they have executed one, as my friend said, the tripartite agreement between petitioner number 1, 2 and the complainant. Your lordship, I have invested my hard-earned money. They have issued me a check that my money is safe and I can withdraw by presenting the check. Your lordship, in the month of February, I have deposited 2 checks that become dishonored. Although I have issued notice to him after 200 days, they have personally assured me that right now money is not available, but it will come. So I have not filed any case. I have not filed any, under negotiable instrument, I have not filed any case, your lordship. Again, only in the month of December, the another 2 checks which I have deposited and on 8/12/2021, that check was also dishonored. Then within 15 days, I have issued notice to him, registered post with registered post. Registered post is slip is also enclosed here with your lordship. Now, your lordship, the most peculiar thing is that, your lordship, after registering the case, someone was issued.
Mr.
Your-
YP Gupta,
Your lordship,
when there is an arbitration clause
your lordship,
with regard to the contract,
your lordship, your
can
lordship.
you take recourse to any other means?
Your lordship, but
Skipping this?
Your lordship, this is a case of check bounce case, your lordship. This is a check bounce case, your lordship. Now, all the accused, they appear in the court, they have obtained bail, and at the time of executing the bail bond, they approach this honorable court. And the most peculiar thing is that, your lordship, petitioner number 1, who is the work order holder, in his bail application, he have written that no tripartite agreement was executed by him, and they have forged my signature in his bail application, your lordship. So, your lordship, this only the proper trial will give justice to the parties, your lordship.
So you don't want to
No,
settle?
I want, your lordship. I
Then
want,
tell-
I'm advising the court. This is the fact, your lordship. And this is totally a check bounce case, nothing to do with the arbitration. Arbitrator cannot decide the criminal
See,
procedure.
litigation benefits none. So this court, with that intent,
Yeah, no, your lordship.
is asking the court to actually go for a settlement.
Yes, lordship, we are agree.
And this is a case where if the parties make an endeavor, they can really settle this matter out of the court.
Lordship.
This is something to do with your agreement, tripartite agreement. So are you willing?
Yeah, my lord.
So suggest a place, neutral place. Where should it be? You are from Arunachal. You are from Nagaland.
Yes.
Why not Gauhati?
So I have already
Lordship, let us
requested them to come to Gauhati, my lord.
Lordship, let us fix a date once. I am agreed to go in Guwahati also.
Okay.
Actually, they have turned down. Actually, that was my proposal and
Okay.
request.
You give us your convenient date. You discuss and you suggest a convenient date.
Lordship, I have a submission to make. If this time has to be given again, even on 16/3/2023, the matter was heard at length. Government advocate, people are sitting made to sit like a hermit, since I have nothing to say. Why-
Because of your absence, the things could not come to this pass.
Even if I'm not.
Give a date. Give a date.
Second week, my lord.
Second week off.
September.
Give a date. Give a date.
My lord, date 15.
Lordship, so my prayer is, see, and again on 12.
Heard Mr. M. Kasar, learned counsel for the petitioner, and Mr. Y.P. Gupta, learned counsel for the 2, 3, and 4. Also heard Mr. K. Angami, the learned PP. On, what is that order?
16.3.
16/3/23.
Sixteen three.
Yes, Your Lordship.
Yes. On 16/3/2023, this court had given 6 weeks' time to the parties to make an attempt to settle the dispute amongst them. Stop. The settlement, however, could not materialize as of date. Today, when the matter is listed, both the parties have expressed their eagerness to go for an out-of-court settlement and therefore request the court to give them one more opportunity. Stop. It is, however, submitted by both by the learned counsel for the parties that the place for amicable negotiation should be in a neutral place like Gauhati, since the petitioner is from Arunachal Pradesh,
My lord.
and the respondent number 2, 3, and 4. Respondent number
Dimapur,
2, 3, and 4
2, 3, and 4.
are from Dimapur. Stop. This court considering that all possible opportunities should be given to the parties to amicably settle the matter between them, is of the view that it will be in the interest of justice if one more chance is given to the parties to negotiate and settle the matter amongst themselves. Stop. Accordingly, the place of the amicable settlement for the parties shall be at Gauhati, and the parties shall sit on 15/9/2026 and 16/9, we are giving you 2 days, and 16/9/2026 to make an endeavor to settle the matter amicably between them. Listed again on 25/9/2022. Yes.
Much obliged, my lord.
For petition, item numbers 3 to 5.
Yes.
Next, Lordship.
Yes.
Lordship, I'll make a mention on behalf of Mr. Praveen Chaudhary.
Yeah.
Lordship, there is a difficulties today, so the letter can be listed on 18th of September, Lordship.
18th of September.
Lordship, kindly, Lordship.
Okay. On the prayer of, Mr. Fuseko submits that Mr. P. Chaudhary, the counsel for the petitioner, is having certain difficulties and therefore seeks adjournment of the case on
18th of September.
8.
1/8.
On 18/9/2023. Prayer is allowed, listed accordingly.
Much obliged.
For admission, item number 6.
Your Lordship,
Yes,
pleadings are completed here, so kindly let the matter come up in the hearing list.
okay. Okay,
Yes, ma'am.
it is submitted by the learned counsel for the parties that pleadings are completed and therefore the matter can be listed for hearing. Listed for hearing in the usual course.
For admission, item number 7.
Your Lordship, on behalf of Thibapom, kindly let the matter come up after 2 weeks.
MS AIME makes a mention on behalf of Mr. E. Tibapom, the learned government advocate, and seeks adjournment of the case after 3 weeks. Prayer is allowed, listed after 3 weeks. Okay.
For admission, item number 10.
May I please, Your Lordship?
Yes, please.
Lordship, I'm appearing on behalf of the counsel for the applicant, V. Devnath.
Yes.
Lordship, I have instructions that this matter may be listed after 2 weeks since the learned counsel is indisposed.
Okay. Mr. So-and-so makes a mention on behalf of Mr. V. Debnath, the learned counsel for the applicant, and seeks adjournment of the case for 2 weeks. Prayer is allowed, listed after 2 weeks. Okay?
For admission, item numbers 11 and 12.
Your Lordship, kindly grant me 3 weeks' time to file my affidavit.
Okay?
Yes, Lordship.
MS AIME, the learned government advocate, is granted 3 weeks' time to file affidavit in opposition. Okay.
Much obliged.
Yes, Lordship.
For admission, item number 13.
Your Lordship, on behalf of Thibapom, kindly let the matter come up after 2 weeks.
What is this matter about?
Lordship, about regularization, Your Lordship, to regularize the service of the petitioners, Your Lordship, separately.
Veterinary doctors?
Yes, Your Lordship. Lordship, what has happened is that initially in the year 2011, Your Lordship, the petition was filed, Your Lordship, against the petitioners, Your Lordship, where the regularization of the petition was first, Your Lordship. However, observation was made, Your Lordship, Your Lordship, saying that since the petitioner have served a considerable amount of time, they HP content and they be allowed to compete with the other service, Your Lordship, and the matter be regularized, Your Lordship. However, their service are yet to be regularized, Your Lordship. We are yet to be considered.
Yes, ma'am. Yeah, ma'am, you're for?
Respondent 6.
Your Lordship, we were yet to file a reply, Your Lordship. Even there is that in the priority response, they have filed your affidavit, Your Lordship. We are yet to file a reply.
State and the private respondents, they have filed.
But private response, they were impleted, Your Lordship. They filed an IA and they were impleted.
So they have filed your
Yes, Your
affidavit.
Lordship, they have filed.
So file your affidavit.
Lordship. 2 weeks time we giving, Your Lordship.
Mr. M. Solo, the learned counsel for the petitioner, seeks for 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the respondents. Prayer is allowed, listed after 3 weeks.
Much.
For admission, item number 14.
Yes.
What is Your Lordship? Your Lordship, I have no objection to the IA filed by the petitioner. Your Lordship.
What is the IA?
Lordship, we're praying for amendment, Your Lordship, and implementing, Your Lordship.
Amendment.
Yes, Your Lordship.
Your IA 74 is for?
74 of the
74 is for?
Prohibit for amendment, Your Lordship. Amendment the post title, the body, and the prayer portion, Your Lordship.
Para 5.
Yes, Your Lordship. Perfect.
The course in the matter of impugn office so and so issued by the paragraph 8A, paragraph 8B, 8C.
Lordship. Yes.
You want to make these additions?
Yes, Your Lordship. I want to amend the petition.
Yes, paragraph 8T, paragraph.
Your Lordship, as well as to impede the Deputy Inspector of Police, Your Lordship, who have issued the
Where have you stated that?
para number 6, Your Lordship.
Para number
Apartment six.
Mr. M. Solo, the learned counsel for the applicant, and MS, any private party?
Lordship, no, Your Lordship, no private party.
Okay, and MS Viveka, the learned government advocate. This application has been filed seeking for amendment of the writ petition number 141/2020. Stop. The proposed amendment is set out in paragraph 5 of the application. Paragraph 5 and 6, correct?
Yes, Your Lordship.
And 6 of the application. The applicant is allowed to file the amendment petition incorporating paragraph 5 and 6 of the application. The learned counsel for the applicant shall take steps with the registry for making the necessary amendment in the writ petition, okay?
Lordship, if I may be allowed to take steps upon the respondent, Your Lordship. Newly implemented respondent, Your Lordship.
And further to take steps upon the respondent number 6,
Number 5, Your Lordship.
upon the newly impleted, correct?
Your Lordship.
Newly impleted respondent number 5. That is,
Respondent number 5, Your Lordship.
that is
Deputy Inspector of Police, Your Lordship.
the Deputy Inspector General. Deputy Inspector General,
No, Your Lordship. Deputy Inspector of Police, Your Lordship.
there is no such post, Deputy Inspector of Police, no. It must be Deputy Inspector General, DIG. Upon, if you give a wrong address, it may never be served. Deputy Inspector of Police, no such post exists, to my knowledge.
Actually, there
Your Lordship.
this IA is being filed against this 16 August 2021 on our affidavit of position we have filed this one. So this is being
Who was-
Deputy Inspector General of Police.
Ah,
The
yes, ma'am.
Yes, yes, yes.
What was that? And further, and further, to take steps upon the newly implicated respondent by serving notice by registered post with AD within a period of
Your Lordship, 1 week. Your Lordship.
within a period of 7 days from today. Stop. MS Livika, the learned government advocate, has no objection to the application. Stop. The application accordingly stands disposed.
Your Lordship, much.
For orders, item number 415.
Yes. What is this? Yes, ma'am.
My pleasure, Lordship. Your Lordship, in this matter, the service is all complete, but still the answers awaited, so
Services,
complete, yes. Next, LCR is awaited, but in the process of
LCR, no LCR. By which order LCR was called for? LCR called for as and is still awaited.
in the last
Okay, office note dated 26/7/2023 shows that LCR called for on 28/6/2023 is still awaited. Stop. Registry to remind the lower court. Listed after 3 weeks.
For orders, item number 16.
My pleasure, Lordship.
Yes.
Lordship, this IA is for condemnation of delay for 107 days.
Who are the parties? Whether notice has been upon or still awaited?
Notice responding 1 and 2 is
What are, please come in. What is this? Yes. Who are the parties?
No, please, Your Lordship.
Yes.
Lordship, I'm appearing on behalf of respondent 1 and 2.
Mr. Tongpok,
Yes, Your Lordship.
where is your, this objection, counter affidavit?
Your Lordship, we have no objection.
You have no objection. And who is for the other respondents? Who are the main respondents? Let's see.
we have received notice to responding 2, but they have not appeared yet.
You take steps once more. Okay? After that, we'll pass the order, since actually 1 and 2 has no objection. Okay? But let us give ample opportunity to at least this fellow. Where is resident of Borgori Gaon? Incomplete address, Sri Benu Gopal, son of so-and-so, resident of Borgori Gaon. Finished.
Yes, Your Lordship, we have only this information.
Even before the tribunal, this was the address. You please try to ascertain the proper address. We cannot allow you to take steps in this address. Okay? You are for the claimant, correct? You should have actually known the address of this person, respondent 3, because you had actually filed the claim petition against this person before the tribunal. You also try an effort, make an effort to get the proper address, okay? Add MS so-and-so, learned counsel for the applicant, and MS so-and-so, learned counsel for the respondent number 1 and 2. None appears for the respondent number 3. Stop. From the records, it is however seen that the address of the respondent number 3 is incomplete. Stop. The learned counsel for the applicant as well as the learned counsel for the respondent number 1 and 2 shall make efforts to trace out the proper address of the respondent number 3 and come informed on the next returnable deed. Okay? Listed after 2 weeks.
For hearing item number 17.
Yes. What about the other side?
Lordship, misbehaved, Lordship, for the government. And then the private respondent has been proceeded ex parte, Lordship.
Ex parte. Where is the government?
Your Lordship, she's not available today, so this may be listed up for some next week, Your Lordship. She's out of station, Your Lordship.
This is 2017.
Next week, Your Lordship.
I think we will have to pass ex parte. Correct?
Even the private respondent, Your Lordship, has been proceeded ex parte by this honorable court, Lordship.
So tell Miss Bailey to come next date.
Yes, Your Lordship. I'll inform her, Your Lordship.
Lordship, if your Lordship pleases, a fixed date may be allowed, Your Lordship.
On the prayer of the learned government advocate. Listed again on 11th September,
Lordship.
Monday, okay?
Yes.
Listed again on 11/9/2023.
Much obliged.
Yes.
Much obliged.
For hearing item number 18.
Call that Zamadar.
May I please, Lordship?
Have you produced the original copy of the gift deed?
The gift deed is not with us, Lordship.
Then?
Because my father died in 1997. So I was not able to find the gift deeds, Lordship. And even then also, Lordship, I am the son of my father.
Don't try to misguide the court, madam.
No, I am not misguiding the court.
The record itself shows that you are misguiding the court.
No, Lordship. There is no attempt to misguide the court, Lordship. There is no attempt to misguide the court.
You produce this original gift deed. or else this will go against you.
I've instructed my client to go for search for the gift deed, but till now he's not been able to get the gift deed, Lordship.
Then how could he mention this gift deed in his letter? If this gift deed was not available, how could he mention this gift deed in the letter? In his letter to the Deputy Commissioner?
It's true, Lordship, it is true, Lordship, but in the mutation order, Lordship, it is Annex 3, Lordship, it is clearly written, mutated and transferred in the name of Sri Piho Kids. It is a case.
Either you bring or we dismiss your case on suppression of facts and misguiding the court.
Then, Lordship, I will be given a chance to produce the original gift deed, Lordship.
You will be given a last chance. Because this court finds that actually the petitioner is not coming with clean hands before this court.
There is no attempt to do such things, Lordship. Because
The record reveals.
I may not be able to produce the gift deed today, Lordship, but that is not a fact, Lordship, that Sri Sikhiwa Sema, in whose name the allotment was made, was not my father, Lordship.
Your case, madam, your case before the court is that your father had actually gifted that land to you.
Yes,
That is your case. So this court wants to see the original copy.
Yes, Lordship, I have made a mention of that, Lordship, but in the allotment order, there is nothing written, Lordship, that it is not a transferable.
Shall I dismiss your petition because of suppression of facts?
No, Lordship, I am not telling that, Lordship. I am not.
You produce the original gift deed as ordered by this court. We are giving you one more chance. And if on the next date you don't produce, we'll dismiss. Nothing more. Okay? On 22/8/2023, this court had directed the learned counsel for the petitioner to produce the original copy of the gift deed, which was registered on 8/12/2015, correct? 8/12/2015. Stop. Today, when the matter is called, MS so-and-so, the learned counsel for the petitioner submits that the direction of this court could not be carried out as, what was the reason? As
He's not able to find that gift
As
in his records, Lordship. But
the
he's-
petitioner is unable to trace the copy of the gift deed. Stop. This court feels that this cannot be a ground for non-production of the gift deed, which was registered on 18/12/2015. Stop. The petitioner is therefore given a last chance to produce the original copy of the gift deed registered on 8/12/2015 on the next date, failing which non-production shall be viewed seriously by this court. Listed again on, Mr. Suppu, yes, you give listed on?
5th September.
I had one wedding. We'll take after the profit. I had a wedding on the
Well, listed on 12. We'll give you ample opportunity.
It will be, if it is possible, it will be on 13, Lordship.
No Wednesday.
11 then, Lordship.
12. Listed
I have-
again.
12, I have another case fixed at Defu, Lordship. So if it,
Your Defu court is important or your matter before the High Court?
all the courts are important. All the courts are important, Lordship. Then it will be 8th, Lordship. 8th of September.
I have personal difficulty, Your Lordship.
A Friday, no. We'll list it on 12. Okay. If not on 12, then we can go to 18.
18, okay, 18 will be open, Lordship.
Yes, please take note of this.
18 will be open.
Listed again on 18/9/2023. On the next date, even if you are absent, even if you don't produce.
No, I'll come, Lordship. I'll come and produce the original deed, Lordship. And the interim may be continued, Lordship.
fact, the interim, we are the last 5-6 years, and this board has met you also.
This is the last date, this is, yes.
What was the interim?
It is status quo was maintained, status quo was directed to be maintained.
Okay.
It is the last date, Lordship, and the last 2 years it was Corona, Lordship. Last 2 years it was Corona, Lordship.
The interim order passed earlier shall continue. Only till the next returnable date.
Lordship.
Yes.
Lordship.
Okay. Okay. It's over.